everyone. Welcome to Legal Talk with Wedlock. I am your host, attorney Emily E.G. Bradford, the founder and managing attorney of Wedlock. Thank you so much for tuning in. This is our episode 2 of the Lockbox for those that may be unfamiliar because we are relatively new. The Lockbox is a safe and secure place for small business owners or their leadership teams to submit legal questions and then join us live on Fridays at 9 a.m. For answers to those questions. So if you're tuning in, you're a small business owner and you think of any questions, we do encourage you to visit www.wedlock.com/legal talk. So thank you again for tuning in. We do have a question from a business owner from Pearland, Texas. Her name is Kristen Bars. She is a licensed professional counselor as well as a life coach. Before we dive into her questions, I do have to give this disclaimer. While I am an attorney, I'm not your attorney until you've actually engaged the firm and completed any necessary paperwork. This post is also for educational purposes only and is not, nor shall it be construed as giving legal advice. So with that out of the way, we'll dive into Ms. Barr's questions. And I'm sharing this because I think she presented really good questions that anyone that is utilizing an attorney or seeking to utilize an attorney with the assistance of their trademark filings should ask. Okay, so Ms. Bars asked the firm, how many trademark applications have we filed? Of those trademark applications, how many have been accepted? How many have been rejected? And then how many were intent to use versus in use applications? So that is great questions, Ms. Bars. Thank you so much for presenting those questions. Nevertheless, we will dive into those answers. So our firm is proud to state that since launching last year, we have filed 19 trademark applications. Of those applications, 5 have been registered, none have been rejected, and there are several pending. 13 are what we call word marks, and 6 are design marks. Before I dive into the difference between intent to use and in use, because it can be a little complicated, I do want to give you all this disclaimer. So Wedlock is a boutique law firm situated in Houston, Texas. We specialize in small business, corporate governance, intellectual property, employment law, as well as commercial litigation. So we are not a firm that is just pushing out trademark applications on a monthly basis. In fact, we probably do more enforcement of trademark rights than what we do filing the application, meaning after you've obtained your registration, ensuring that it maintains protected and getting you what's rightfully owed in the event of infringement. But with that said, I say that because if that number appears to be a little low, that's in particularly why. Nevertheless, no matter what someone's experience is, it's definitely important to ask those questions so that you can make an informed decision. Some people may be very well okay with taking a chance on you as an attorney, but attorneys should be transparent and honest about their past successes and representations in those areas. So now we're going to dive into intent to use versus actual use. So she did ask how many of those applications. So of those 19 applications, 10 of them did include a designation of intent to use classification. So what does that mean, right? Well, let me start here. If you are interested in protecting your brand on a federal level in terms of federal trademark registration, then you're going to have to file it with the United States Patent and Trademark Office, what we refer to as the USPTO. In doing so, you're either going to file a word mark, which is a standard character mark, or your logo or design, or maybe perhaps you're going to do a designation of both. But in any event, with whatever you're filing, you're going to have to select certain classes that relate to those goods or services. So the USPTO has a ton of different classes that kind of separate your they separate your products from your services. So if you have a mark and you plan on using it for like apparel, that would be class 25. But if you plan on using it for services like life coaching, that would be 41, or legal services, that would be 45. Now, when you select your classification, you also have to designate whether or not that is in use or intent to use. So in use means that you are currently using that mark in interstate commerce. For purposes of federal registration, interstate commerce means anything outside of the state in which you're operating. So let's say you have an e-commerce site and you're selling products to customers all over the United States. That's certainly interstate commerce. But let's say that you just have a mom and pop shop within a state and you are not selling to anyone outside of that state. You have no plans on expanding outside of that state. Then that may be better situated for a state trademark registration. Either way, you have your federal and you have your state. You're going to have to show interstate commerce for purposes of an in-use federal trademark registration. If you do not have that, but you just have plans of doing that in the future, or maybe it's that you have a particular logo or a brand that you don't want anyone else infringing on, because trademark registration is on a first come, first served basis, right? So if you have plans to use a mark, then that's what we use as an intent to use designation. So it's either you're in use in commerce, or it's intent to use, you intend to use this in the future in commerce. Nevertheless, for federal trademark registration, it is in commerce. So I hope that those answers your questions, Ms. Bars, and anyone else that may be having similar questions as it relates to our firm. I will say that other questions that you may want to consider if you're planning on using attorney with your trademark registration is asking them, what does this process look like? How long does it take? Are there any other things that I need to consider? Do you have experience with responding to office actions or oppositions, which are both things that happen throughout the trademark application process, or that can happen throughout the trademark application filing process? So ask them if they have experience with that. And then following your registration, do they give you guidance on post-trademark enforcement, like monitoring your mark and making sure that it does not become diluted or generic? Because if that's the case, then you can lose, the protection in which you have. I'm sure you all are familiar with Taco Tuesday. That's kind of what happened there. So the USPTO, after you actually obtain registration, you have 5 years to challenge it, okay? And so if you're not monitoring, if you're not enforcing this mark, then somebody very well can move to cancel it on the grounds that it's become generic because they want to use it. So with Taco Tuesday, that was kind of what happened. You had a bigger company that came in and filed, a cancellation petition with the USPTO, essentially saying that their mark has become diluted and generic. You had everybody around the country using it, LeBron James and things of that sort. I have not looked at it in months, so do not quote me on anything in particular, but from my understanding, it just, the small business owner kind of gave up that fight. And that's not uncommon when it comes to trademark infringement and things like that. So nevertheless, ask those questions. Ask them what their experience is in enforcing these marks. Can they litigate them in the event that, there's an infringer that is refusing to comply with your demands? That's important to know. You want an attorney that can not only register the trademark, but that can see you through it should you need assistance with enforcing it. So thank you all so much for tuning in. We hope that you've learned something. If let me see. Yes, if you have legal questions, make sure to submit them to the lockbox, but also subscribe to our YouTube channel at Legal Talk with Wedlock. That's LTWWL. You can follow us on Facebook, Instagram, and LinkedIn as well. Next week, we're going to be talking about holding companies and the importance of them and how to get them established. So it's our hope that you tune in and that everybody has a great weekend.